I wish it would just be simple. Why can't you just give me the nice simple, they can't force you to do it, but you're giving me both. Yes, they can, and no, they can't. It depends on where the line is.
And that simply reflects the nature of this 20th century rights jurisprudence. It is very, very squishy. For example, the courts define certain rights as fundamental. Well, what makes a right fundamental, like the right to travel, the right to privacy? What makes that fundamental, and not the right to collect your rent as a landlord?
Right.
What makes that not fundamental? Simply because the 20th century court said so.
If you haven't had your vaccine yet for COVID, please just go get it. It helped me. I got COVID, but I had the vaccine, and it made it like not a big deal. But the question is, should you be mandated to get that vaccine if you want to keep your job, if you want to go to school, or if you just want to live? Our constitutional scholar, Rob Natelson, has an answer for everything. So tell us, Professor.
Well, unless you've got some health reason not to do it, you should get the vaccine, but that doesn't mean the government should tell you to get the vaccine.
But I'm seeing here locally that the governor is saying if you work for the state, you need to get the vaccine. School districts are telling their folks they need to get the vaccine. And I got to tell you, part of me feels pretty good about that because I want the schools open. I don't really want the government open, but I want them doing their functions. So what's wrong with an employer mandating you've got to get the vaccine?
Well, if it's a private employer, I don't think there's anything wrong with it. As a matter of policy, a private employer should act reasonably. I don't think it's reasonable to force people who've already had COVID to get the vaccine, but I'm not a physician. It's where the employer is the government, or where the government is running a state university, as just happened in a case involving Indiana University. Then it becomes problematical. Because you get constitutional issues involved.
Before we jump into that, you said something, if a private employer is doing it, well, that's not a big issue. Let me push on that. I want to see if I agree, because I don't know if I do. Now, your employer can't discriminate against you for a whole host of reasons. Your religion, your race, your sexual orientation, your gender. They apparently have to hire left-handed people now. I mean, it's crazy. So why is it that an employer can say, hey, you want to work here, you have to put this drug into your body through a syringe. Otherwise, you can't. I mean, it seems to me that a lot of those things, your sexual identity, your religion, that's kind of from the skin in, and not, it's not like a dress code. It's my own body. What gives in a private, and let's underline private employer?
Okay, private employer. We tend to, John, we tend to forget this because there's always so much discussion of discrimination. But the word discrimination technically only means choice, right? And the default rule, the rule we apply unless there's a specific law to the contrary, is an employer can discriminate on any grounds he wants. If he doesn't like the fact that you're wearing a maroon shirt to the job interview, he can say, I don't want that guy around. And that's perfectly legal.
But if he fires me because he doesn't...
Even if he fires you because you have the shirt on, that's still okay, unless you have a particular law in the state that prohibits firing without cause. So again, the default rule is that the employer can fire or hire for whatever reason he wants. And it is only in those areas that the government has identified as invidious discrimination based upon sex, for example, or based upon religion, or based upon race. It's in those areas where the employer no longer is prohibited to discriminate. But if it's based on the color of your shirt or whether you've been vaccinated, that's fine, if, of course, it is a private employer.
All right. Let's go one step. Let's not go to students yet. Let's go to the government and their employees. So Jared Polis here in Colorado says if you get a check, you're either going to have to get a vaccine or get tested 15 times a day or whatever it is. Biden has done that with federal employees. I think it's happening in school districts. Hey, you want your job? You're going to get the vaccine. Well, that's the government telling people to get a vaccine. Is that unconstitutional?
I think it's problematical. And here's the problem.
First of all,
Yeah.
is a word like problematical something that lawyers say instead of saying, I don't know, because lawyers can't say, I don't know?
Well, this lawyer can say, I don't know, but I prefer to say problematical. And the reason I say that is because if I just said, I don't know, it would be interpreted as I don't have a clue. I have a lot of clues. What I don't have is the solution to the case.
Got it.
Let me explain what I mean. All through the 20th century, the U.S. Supreme Court built up a massive body of constitutional rights jurisprudence. So we always had constitutional rights to freedom of religion, for example, or freedom of speech. But progressive majorities on the Supreme Court during the 20th century added a number of rights, including privacy, personal autonomy, bodily integrity, the right to travel. They created these rights and they called them fundamental. The right to abortion derives from the right
Of
to
privacy.
Yeah. So then...
Pardon me. Under which part of the Constitution do the courts come up with things like autonomy and privacy?
Usually it's the two due process clauses. The due process clause of the Fifth Amendment that applies to the federal government, and the due process clause of the 14th Amendment that applies to the states. You don't need to guess that I don't really approve of this body of law because I don't think it's rooted in the Constitution. Nevertheless, it is the law of the Supreme Court. In addition to that, they created a structure called the tiers of scrutiny. And what that means is if you're violating some important right, like the right to privacy, if the government violates it, then the government has to go beyond merely proving that the violation is a reasonable one, but they've got to meet a heightened test of some kind. And the actual test varies with the circumstances on the right. Now, if you were to say to me 2 years ago, if government agencies were ordering employees and others to be vaccinated, as Indiana University ordered its students to be vaccinated, is that constitutional? I would say, well, no, it's not constitutional unless you have a pandemic, it's a serious situation, and the rule is finely tailored, closely tailored to the problem. So, for example, you might want to, a court might uphold a vaccination of an old person who is subject to great risk from COVID, but wouldn't uphold the vaccination of a young person who really has very little risk from COVID. That's what I would have said 2 years ago. What has happened, however, is that the courts have, I've said, essentially gone AWOL on COVID. For everything except freedom of religion, there are some cases where they've stood up for the freedom of religion, but on the right to privacy, personal bodily integrity, the right to travel.
What is bodily integrity?
Well, it basically means the right to control what goes into your body. So as to those rights, the courts have simply pretended like all of this 20th century constitutional rights jurisprudence doesn't exist, and what we're doing is we're back to 1905, applying a 1905 case to the situation.
So there was a meme. My favorite meme out of the last year and a half was that great painting of this, the Constitutional Convention in Washington, and all our founding fathers, and there's a document, and the meme just said, one of them saying, now to be clear here, none of this applies if there's a pandemic.
Yeah.
Or if there's a virus, I think.
Yeah.
None of this applies if there's a virus. And I have been amazed how not any, but a lot of this stuff ever held up. These ideas that we can suspend your right to religious worship, your right to freely associate, your right to make a living. But the courts seem to say this is a big deal, and we're just gonna say no.
Let's go through each of those. First, the right to freedom of religion, free exercise of religion. The Supreme Court has been supportive of this, insofar as it has said that you can't close the churches and synagogues down while keeping the pot shops open. You can close the churches, but you've got to treat other assembly areas the same way. And that, by the way, is consistent.
Is that a federal court ruling?
Yeah, that's the U.S. Supreme Court. And that is consistent with precedent. In the area of freedom of association in the First Amendment is really a political right. It refers to political association. It really doesn't have to do with frequenting local businesses. So that has not been...
Although, wait a second. During all this, it seemed as though if there was a BLM riot, that was protected.
Well,
but if there was a Tea Party,
but now you're not talking about the courts. You're talking about people who are public health officials who say, don't go visit your grandma who is 80 years old, but instead go out and riot for BLM. I mean, that's a whole different issue. It's not a constitutional issue. It's an issue of some kind of mental deficiency that some people have. But where we've seen it most, where we've seen the odd reactions from the courts, where they're going AWOL, is precisely in these areas where they've built up this jurisprudence, right to travel, bodily integrity, privacy, and so forth. And right to travel is a great example. Jared Polis, early on in this process, issued a decree, and the city of Denver issued a decree, which basically tried to stop interstate travel at the border of Colorado. It said you can't travel more than 10 miles away from your home or outside the county, right? What gives them authority to do that? Nothing that I see really in the law and certainly not in the Constitution. And there were decrees like that all over the country. You can't travel more than 10 miles. Excuse me? There's a federal right to travel. It's supposed to be a fundamental right. And yet, to my knowledge, no court ever stepped in and said, this goes too far. You may be able to restrict the right to travel to a certain extent, but you've got to do it in a finely tailored, narrowly tailored way, not just a general rule that you've got to hunker down in your house.
Let me try a couple out on you.
Yeah.
So having kids in government schools, you have to show vaccinations, which is, did you have your smallpox vaccine or your chickenpox vaccine? I forget what it is, but you enroll your kid into kindergarten or first grade, and they want to see this stuff. And it was my understanding, and maybe I was wrong, that unless you're willing to go through a lot of hoops, you really have to get your kid vaccinated in order to avail yourself of a government education. Well before the pandemic. So was that also unconstitutional?
Not necessarily. It's not.
If not, then what's the difference?
Okay, it's not. Look, the way public health laws like this are tested under this 20th century jurisprudence is that first, is there a compelling governmental purpose behind the restriction? And I think preventing a pandemic is certainly a compelling governmental purpose. But the other requirement is that the restriction be narrowly tailored, or at least somehow fit the circumstances. Chickenpox is a dangerous disease for kids. I lost half my hearing as a result of complications of chickenpox. It is absolutely appropriate. It is finely tailored to say that a kid should be vaccinated against chickenpox. Smallpox, the leading Supreme Court case which upheld mandatory vaccinations involved smallpox. Smallpox used to kill 1 out of every 3 persons it inflicted. If you're talking about someone who is 60 years old and is working for a government agency, that person is at risk for COVID. I think even the progressive era jurisprudence would say, that person needs to be vaccinated as a condition of working in the job. Where things get dicey is where your order is kind of a sprawling one, what we lawyers call over-inclusive, includes a whole lot of people it doesn't have to include. So the case that the U.S. Supreme Court just rejected effectively upheld the requirement from Indiana University that everybody be vaccinated.
Including students.
Including kids of 18, 20 years old who are effectively under no serious risk of COVID. They have to be vaccinated. Under the 20th century jurisprudence, that kind of order should be suspect. Similarly, if we ordered, if we ordered school kids to be vaccinated against some disease that afflicted only the elderly,
right.
I mean, that would
right,
be.
So let me kick this back to you, see if I'm getting this. Well, you might not agree with what you call jurisprudence, which, if to to a layman, that's just basically
Bunch of cases.
Bunch of cases. It's what precedents have kind of built up over time. If the courts were consistent with what they've been doing for the last century, there's no way these types of mandates would stand. So they've had to fly in the face of the rulings that they've been doing for the last century.
That's right.
And do they have to give some sort of reason, saying, hey, I know in all these other cases we upheld people's, you call it bodily integrity? Is that
bodily integrity, privacy?
I'm going to try to find a way to because I've heard that on a lot of dates. I've got bodily integrity.
Right.
So
it tends to go up when you're there.
Yeah, I know. It's amazing. More hurdles. So, do they give a reason, or is it because with judges, for a layman, politicians, you understand, they either voted for the bill or they didn't vote for the bill. The president either vetoed this bill or he didn't veto this bill. With judges, it's this wall of oatmeal, and it's hard to know what they said, which I'm pretty sure is just a way to keep lawyers employed.
John, a great example is the case that came from the United States Court of Appeals for the Seventh Circuit, which upheld this order of Indiana University requiring kids to be vaccinated. The court went right to a case called Jacobson versus Massachusetts that I want to say something about. Comes from 1905. And then when they came to deal with the modern jurisprudence, it's kind of swept it aside. I mean, in a way that is really not very persuasive. There's a right to bodily integrity, but we got the Jacobson case, overlooking the fact the Jacobson case was decided long before the modern cases were. And the other thing is that the courts have tended, and they've recited this Jacobson case too, again and again, not just for mandatory vaccination, but for a whole lot of other COVID restrictions. And they never really look at the Jacobson case seriously and say, what did the court really hold? And what the court held in that case was that the city of Cambridge, Massachusetts, home of Harvard University, source of all bad ideas, that Cambridge, Massachusetts could require adults to be vaccinated against smallpox. Now, here's the difference. A, smallpox kills 1/3 of the people it afflicts. COVID kills less than 2%. B,
and if you're younger, far less than 2%.
And B, smallpox kills everybody, doesn't discriminate.
Right.
COVID kills the elderly, right? And you're dealing with a mandate directed at students. Thirdly, and the court points this out, at the time the smallpox requirement was upheld in 1905, there had already been over a century of experience with the smallpox vaccine. We knew it worked. We knew it didn't have bad side effects. We don't know that about COVID. Now, I'm old. I readily got the COVID vaccine because I'm not going to worry about side effects 3 decades down the road. I probably won't be here. But a 20-year-old might want to take this under consideration. So I'm not necessarily saying that the courts should strike down all vaccine mandates. Maybe they should uphold both of them, most of them. But I'd like to see a little bit more analysis. I'd like to see a little bit more proof.
I know a woman who hasn't had her vaccine yet, and she's not what you call an anti-vaxxer. She's just like, up to that point, it hadn't been approved by the FDA.
Yeah, right.
Her doctor said, you've got these kind of conditions, and we don't know how this interacts with those conditions. And so I'd like to have more time to find out where this goes. So, in other words, the newness of this vaccine, and if Trump didn't do the Operation Warp Speed, which he gets no credit for, then we wouldn't have a vaccine for another 3 years. And so maybe then people would be satisfied that it went through all the right processes. So one of the things is the drug or the COVID discriminates mostly against older people and people with immune issues. We haven't had a whole lot of time with this vaccine, so we don't know what it is. And the mortality rate compared to other things that are mandated is pretty low.
And there's also the issue of how effective the vaccine is. The most vaccinated country in the world right now is Israel. Over 70%, I believe, of Israelis have been vaccinated. But it's also true that something like 70% of the new COVID cases in Israel are from the vaccinated population. Now, there are reasons to question those figures, right? But the point is that this is all sort of up in the air. And what it suggests is that when you're responding to an emergency like this, our political leaders need to be a little bit more thoughtful and a little less heavy-handed.
Yeah, you just keep on saying that.
Yeah.
All right, let me try it this way. A shot in the arm, I just have such a hard time with the government mandating. I mean, I could see when people are scared to say, no, the mandate is you get it. You get, I don't care what you do, we're coming to your door. It's going to be a nurse with a syringe, and we're all going to get it because we're going to have to put this behind us and get herd immunity. Thank you.
Herd immunity.
Thank you. Easy for you to say. Because people are saying, no, it's my body. You don't have a right, just because you have the collective behind you, to force stuff on my body. Well, then let me be Milt Friedman for a little bit. We've had conscription throughout our history. As a matter of fact, it ended in the 70s, and anybody raised after that never had to worry about getting drafted. Before that, people did. The government actually said, instead of just putting something in your body you don't want, we're going to take years away from your life. We're going to put you in dangerous situations where you could be killed for what we think is in the best interest of the nation. Oh, and by the way, we're going to pump you through so many chemicals. Yeah. This COVID shot seems like nothing. Yeah. You get malaria and diphtheria, and you're just getting shots left and right. A lot of them did a fair amount of damage. How is that constitutional if you're telling me that this shot shouldn't be constitutional?
John, you're
conflating two things.
You're talking to an originalist here, and so I'm going to use this opportunity to make the point that what you just identified demonstrates the incoherence of this 20th century jurisprudence. In the Constitution, there is no right to bodily integrity, right? There is a right to free speech. There is a right to freedom of religion. There's a right to keep and bear arms. There are rights listed in the Constitution. There are not made-up rights like the right to privacy or the right to bodily integrity. And
Aren't
so
there,
when the court...
Wait. Aren't there rights that have yet to be enumerated? Wasn't that the whole idea of the 9th and 10th Amendment that said...
The 9th Amendment was designed for a completely different purpose. The 9th Amendment was designed to communicate...
Have you even read the Constitution?
Yeah, right. The 9th Amendment was designed to communicate that simply because we have some limits on government power, federal power in the Constitution, doesn't mean the federal government has the power to do everything else. The use of the word rights in the 9th Amendment is actually an anachronistic use. There's a great book on the subject, the original Constitution, that explains
all the critics panned that book.
So in other words, this is one of the problems that happens when the courts get involved in making up rights. I mean, why is it for? Let me give you a concrete example. The courts are allowing Indiana University to say, in order to preserve human life, every kid has to get a vaccination, right? Unless we give you a religious or a medical exemption. Suppose Indiana University said, we're so concerned about human life that we're going to make every student sign a statement that they will not obtain or encourage an abortion while they're at Indiana University, because we're concerned about that. And if you have a religious objection to that, if your religion requires you to get an abortion, or if you have a serious medical problem which requires an abortion, well, then we'll consider that.
We'll give you permission.
Yeah, right. So that's the rule from Indiana University on abortion. How many minutes do you think that rule would survive in the courts? Right? Probably about half a minute. And so it illustrates the incoherence, really, of the judges trying to make up rights. However, given the fact that they have made up rights, given the fact that they've got all these cases, it seems to be the rule of law at least should require them to follow those cases and not to run away from them as soon as an inconvenient plaintiff appears.
I threw out the draft.
Yeah.
Is the draft constitutional?
Oh, yeah. Yeah.
How is the draft constitutional?
It's constitutional because Congress is given the power to raise armies. And conscription, at the time the Constitution was written, conscription was an incident. It was something connected to the right to raise armies. It was universally recognized internationally as a way in which armies could be raised.
So basically, if we want to vaccinate everybody, we could just draft everyone. That would satisfy your complaints.
Oh, right. If they draft everybody, even the progressive majorities of the 20th century said, once you're in the military,
your body ain't your own.
A lot of these rights, these rights don't necessarily apply.
Talk to me about the different levels here. In that, you've got Biden saying that everybody works for the federal government, you're going to get vaccinated. You've got Polis saying it for here, and then you keep going down. At some point, we have a library district or a water district, or as we saw with one of the Park and Recs department was going to take on gun control and take away your carry permits because it has nothing to do with their mission at all. They can't enforce it, but they're going to do it. All right, if these other governments can do it, why can't the cemetery district or the RTD district demand that everyone get a vaccine?
They can. Again, I'm giving you a Supreme Court doctrine. Remember, you asked me, where do these rights come from? Where do these rights come from? The Due Process Clause. The courts say that these rights apply all the way down from the federal government to the state government and all subdivisions of the state government. So if a cemetery district says that everybody who enters a cemetery has to be vaccinated first in order to protect, then you apply the same analysis. Now, presumably what a court should say is that, if a cemetery district dictates that you be vaccinated to enter the cemetery, that seems to be over-inclusive. That seems to be too broad. A, the dead people can't get COVID, and B, you're outdoors, and really that COVID is not easily communicated outdoors. But you would apply the same rights analysis.
I wish it would just be simple. Why can't you just give me the nice simple, they can't force you to do it, but you're giving me both. Yes, they can, and no, they can't. It depends on where the line is.
And that simply reflects the nature of this 20th century rights jurisprudence. It is very, very squishy. For example, the courts define certain rights as fundamental. Well, what makes a right fundamental, like the right to travel, the right to privacy? What makes that fundamental? And not the right to collect your rent as a landlord. Right. What makes that not fundamental? Simply because the 20th century court said so. They privilege some rights over the other. Then some rights can be circumscribed with a compelling state interest, some only with an important state interest, some with an actual reasonable state interest, and some with any conceivable state interest. Where did all those tiers come from? Well, the whole bunch of glop was invented by progressive majorities in the 20th century. Again, that's why I'm an originalist.
Judges.
I believe in enforcing the Constitution, not what these judges came up with.
If you could go back to before the 20th century, and you had the law of the land during the 20th century, what would be different? As an originalist, what would have happened to all these rights that we now have, that the courts have said we have, that the Indiana case says, except in this case, you don't have it.
Right.
What would Justice Natelson do in all from the beginning?
John, it's too broad a question, so I'll have to answer it in very broad ways. First, I would limit my jurisprudence to enumerated rights. Okay, there's a right to free speech. I would defend that, and the way I would defend the right to free speech is not according to whether the interest is compelling or important or anything. I would simply go back to what the founders meant by free speech. There would be, for example, obscenity was not considered free speech. Treason was not free speech. And I would apply the classifications that were understood to be free speech at the time. Same thing with the right to keep and bear arms. I would refrain from creating other rights. Take privacy, for example. I like the right to privacy. I lived for many years in Montana. There's a provision of the Montana Constitution that protects the right to privacy. I think that's great. But as a judge, it's my obligation to apply what the Constitution says and not what I think would be great, And so that's where I would differ. And in some areas, like the right to keep and bear arms and certain economic rights, I would be more vigorous in defending them than the courts have been, because that's what the Constitution requires.
A couple of things. One, you mentioned this terrible book about the Constitution.
It's a wonderful book about the
terrible
Constitution.
book. Actually, let's give a plug for it. It really makes a difference on it. Your book. Where do people get it?
You can pick it up at Amazon, or if you're angry at Amazon, you can pick it up at barnesandnoble.com. The title of the book is The Original Constitution, What It Actually Said and Meant. Be sure you get the third edition, the most recent edition. The Original Constitution, What It Actually Said and Meant, by Robert G. Natelson.
This is how my college teachers always made extra money. No, you got to get my textbook. Yeah.
You know,
you got to get the most latest.
I never did that.
Really?
Yeah, I wrote, when I taught courses in law school, I very often provided either a textbook of my own or a supplemental material. I never charged a dime for it, and I never earned anything from it.
Well, that's why you're working at the Independence Institute.
Yeah, right.
You've got a track record of not earning a dime.
Because you know I can be taken advantage of.
One last thing here. Your column at the Epoch Times has now really started to take off. You're now a weekly columnist there.
Yes.
Talk to me about this paper, because when people hear about the Epoch Times, that's a crazy newspaper. Those are a bunch of whack job right wingers, and I don't think that's the case. What is this newspaper?
Well, it's been attacked by Wikipedia and the usual suspects, of course. It was a newspaper that was founded by a man named Jon Tong, who was essentially a refugee from communist China. He came here as a graduate student and decided he wanted to stay here, got his permission to stay here, and said, I would really like to start a newspaper to tell people what's going on inside communist China, because there's a lot of news there. Well, it sort of caught on. It eventually started covering news around the world. So now there's U.S. news and Australian news and Canadian news. It's published now in 23 languages, in more countries than that. They have offices all around the world.
Is it Epoch Times? Is it Epoch Times? Or is it? I can't remember the third one.
John, I recently went to New York City, their headquarters. I gave a speech. Alan Dershowitz and I shared the platform.
That must have been cool.
It was great. And Alan Dershowitz and I got along well. He and I have slightly different expertise. He's more of a civil rights, civil libertarian. I'm a general constitution guy, but we learned a lot from each other. But anyway, one of the things I wanted to learn is, do they really pronounce it Epoch Times or Epoch Times? And I can report to you authoritatively that people in New York City at the headquarters pronounce it both ways.
Rob, thanks for everything.
Thank you, John.
Appreciate it.
Yeah.
If you enjoyed that conversation, by all means, click one of these other great programs. We have the best conversations with the most fascinating Coloradans. And subscribe to our channel. Just click down below and hit that little bell button too. You don't want to miss a single show.